Tonight, a litmus test of the character of the third accused person in the ambulance purchase trial reveals new information. Chief of Defense Staff Lieutenant General Thomas Oppong Peprah corroborates evidence Richard Jakpa was not released honorably from the Ghana Armed Forces. Now, the CDS, who is a defense witness, however, denied claims that the reason for the release from the military was misconduct. He testified that Jakpa was released over a lack of interest in the service.
Specific case is applicable under item 2A.
My lady, inefficiency, and it has three things covered.
Did the military's letter cover all the three things?
No, my lady.
Which one did it cover?
Through continued lack of application or interest.
So, now, from all the factors and circumstances regarding Mr. Jakpa's release from the Ghana Armed Forces, would you say that he was honorably released from the Ghana Armed Forces?
My lady, as per the document that is on record, he was not honorably released.
That he was not placed on the retired list. Is that not correct?
Yes, my lady.
And he is also not permitted to use his rank in civil life. Is that not correct?
Yes, my lady.
Information regarding a past serving or retired military officer cannot be released to any other person except with your express authorization. Is that correct?
It's not, yes, my lady, it's not wholly true. I have a supervisory ministry, and they are entitled to receiving my classified documents.
The Ministry of Defense doesn't have operational administrative control over the military. Isn't that correct?
The Ministry of Defense comprises of the military division and then the civil division. The military division is commanded by or controlled by or administered by the Chief of the Defense Staff. The civil division is controlled, administered by the Chief Director, and both answer to the supervising minister as the Minister of Defense.
Well, so if you missed the hearing today, you just caught snippets of that. Now, this so-called dismissal letter, now evidence of the court, has become a thorn in the flesh of the defense as they battle to clear Richard Jakpa of any wrongdoing. But what do these jargons mean, and how do they transform the case? I want to bring in now Dr. Justice Serwaa, who's a lawyer and law lecturer. Good evening to you, Doc. This case has moved from the ambulances themselves to the character of the third accused person. What could the strategy be, really? And what does knowing whether or not he left the military honorably got to do with this case?
Thank you very much, and good evening to your viewers. In a criminal trial, generally, a person's character comes to question if he seeks to rely on his character as a defense, or he is using another person's character in the process. So what is happening, what we seem to be seeing is that it appears in the trial that the accused person's character is in question because possibly the prosecution believes that without assailing his character, without impugning his character, he is likely to succeed in his defense. And I think that's the only way that a prosecutor would be interested in the character of an accused person or a witness. So in this particular case, be that as it may, character has become a center stage because don't forget that the accused person seems to have also questioned the character of the Attorney General. Mm-hmm. So you put all these together, it has become, the character has taken a center stage, quite apart from the allegation concerning the ambulances, because character of the prosecutor, the character of the accused person, the character of some witnesses have come to play. In such cases, I mean, the character always will play some role in the trial.
I see. Essentially, at the end of the day, the court will take the decision whether there was merit to that or not. But tonight we learn that the letter didn't have the letter as referred to didn't have the use of misconduct as reason for his dismissal. The CDS then reveals that he didn't release the letter to the defense minister, which then got to the attorney general. Is that problematic for the prosecution? Who got that letter into evidence?
It definitely may be problematic for the prosecution, because as a prosecutor or as someone who is seeking to rely on a document to impugn the character of an accused person, you want that document to be holistically accepted and a lot of weight be put on sale. It appears that the source of the document itself is an issue, which is actually causing the Chief of Defense Staff to actually say that he did not authorize the release of the letter. And secondly, if you are tendering a document, and a document which has clearly been marked confidential, then a lot of questions of authenticity, a question about the source who released the document would come to play. So at this point, the Chief of Defense Staff saying that he did not release the letter leaves the question open: how did a letter which is clearly marked confidential come out? And one aspect of the trial which seems to come out clearly now is the question that the third accused person, Mr. Japa, is denying knowledge of the allegations in the letter. And we know that by way of constitutional provision, a person cannot be condemned in a matter which he has not been given a hearing. And if indeed he is not aware of this letter, and is not aware of the allegation in some of the letters or the documents we are seeing, and those allegations were not brought to him and he was heard thereon, then clearly there will be a problem with the use of the letter itself. However, as it stands in this case, the CDS has told the court that the letter itself did not make any allegation of misconduct against the third accused, and went on to state that the letter only said he was not interested, he lost interest in the military. And so losing interest in the military, I think we both know cannot be grounds for saying misconduct. Loss of interest is really grounds for misconduct in this case.
Indeed, Doc, I want to now look at the admissibility of the letter itself, particularly now that the CDS or the Army Chief has said, look, I didn't release this letter. I don't know how they got it. We know, let's look at it from the perspective of the judge, right? The judge hitherto admitted that leaked audio into evidence. She's done the same with this letter whose source is not known. And under what circumstances do such unknown sources of evidence become important to the court?
So the general rule is, which guides our evidence, proceedings in court, is that anything is admissible so long as it's relevant. It doesn't matter how you procure it, whether you stole it, whether it was smuggled, whatever, it will be admissible. That's the general rule. However, what matters, and as of now, the letter is in evidence, so the question of admissibility is behind us now. What we are probably looking at now is the weight which the judge would put on the letter in her assessment of the facts, the weight that he may put on it. And beside, getting the weight is where the question of source may come in, because if you are bringing something which is not of a clearly known source, it will affect the weight. Secondly, the interpretation being put on the letter by the Attorney General also seems to be different from what the CDS has said. While the Attorney General is using the letter as evidence of character, of bad character, the CDS is saying something other than that. So what it means is that even the purpose or the implication which the Attorney General is urging on the court, as far as the letter is concerned, seems unsupported by the evidence we saw today. So all this will go into the assessment of the weight which the judge will put on the letter and how the judge will construe it.
Indeed, Doc, thank you so much for talking to us. Dr. Justice Serwaa is a lawyer and a law lecturer. We are not done with this subject, because another term we have become used to in the course of this trial is dishonorable release. But what does it all really mean? For more on that, let's bring in Dr. Victor Doke, who is a security consultant and lecturer at the Kofi Annan International Peacekeeping and Training Center. Doc, good evening to you. Let's get some education on this term. Does it exist in Ghanaian army jargon, and what does it really mean?
Thank you very much. It's a jargon used in the security circle, and that the army can use it, the police can use it. Now, dishonorably, it's just something like the institution and then the person in question coming to a very amicable conclusion. And the subject has acknowledged that per what has been observed by the hierarchy, that subject cannot continue with his or her duties based on some reasons that him or herself knows that he cannot or she cannot continue. So it's an amicable settlement of a sort.
Right.
Two entities, the institution and the subject matter in question, have come to the conclusion that this is it. I know personally, I have come to the realization that what I have to do, I cannot do it henceforth.
Very well. So, Dr. Doke, based on what you have described, how is it different from outrightly being dismissed from the army?
To be dismissed from the military or security institution is that the person to be dismissed has conducted himself or herself in a manner that is contrary to the standard operating procedures of the said institution. So dismissal comes in the form of an outward, straight, outright dismissal, to be asked to go out entirely. There won't be any sort of investigations, there won't be any sort of committee formed or board formed to come to a conclusion on your matter. It is either the person in question has exhibited himself or herself in a manner that is contrary to the SOPs of that said institution, which even puts that person in harm's way, or the institution in harm's way, or in a bad light. So outright dismissal is a straightforward process, asking to go home without any form of committee setting up or investigation to look.
Very well. So I mean, without prejudice to the case, when someone says they were dishonorably discharged, it doesn't necessarily mean they conducted themselves badly.
So if the person has been dishonorably discharged, it may not necessarily mean the person has conducted himself badly. One, so you are talking about two things here: the character of the person, and then two, conforming to the standard operating procedures of the said institution. So these two different things. So which one, is the basis for dishonorably discharging the person?
Right.
So, I mean, it has to be looked into. So if the person's character and person, comes into question, the person can be discharged. If, when it comes to the SOPs, the person can also be discharged.
Very well. So Doc, I want us to look at the contentious letter. Today we heard how the CDA says, look, I don't know how you got it. It didn't come from me. How does this make the operation of the whole, army machinery look?
Well, one question that comes into mind is, now, let's say this was a very sensitive information that puts the country at risk of being attacked in any form. And if we have a person who has volunteered intelligence in that regard, then it means that the person's details has been put out, by that threatening the life of the person and then the country at large. Now, how can an institution like this, with the very stringent and very uptight process of even getting information, have a lapse like this? Now, this is one big gap that has been has been exhibited. Now, whoever put out the information without the knowledge of the army chief, the CDS, I think there has to be a thorough investigation to that matter, because
very well,
some of us don't look at it in this in this light of events, but we are looking at it in a different light.
Absolutely, Doc. You know, as my earlier panelists or guests had noted, Richard Jakpa himself has said that he has not seen this letter before, 17 years after he's left the military. Nothing of that sort has come to his notice. You have told us a few things about the processes the processes that occur when somebody is either dismissed outrightly or discharged honorably from the military. But is it possible for someone to be released dishonorably without them receiving notice of the same?
Well, when you are let go, in this case, there has to be a detailed process. A detailed process, I mean, you, the person being let go, have to know why. It has to be spelled out. Everybody has a file when even private entities or whatever you want to call it. Everybody has a file. When you are even given a query, that is put on there. Okay? So when, in this case, the said gentleman has to get some detailed information put on his file to know what exactly happened, why he's let go, okay, whether there have been any settlement or whatever, and he has agreed to it. Now, if there isn't something like that, then I think they have to look into it. So after all these years, if I have not received any form of notification of what went wrong, then that tells me that our institutions mandated with regards to security should put in place mechanisms to recognize the fact that when you are letting go an official or a member of your organization, then you owe it that duty, that right. Okay.
Very well. Very well indeed. Doc, I'm afraid we'd have to end our conversation here. But, you know,